Your Honor, I take full ownership for mistakes I have made, but I want to be clear that this motion only tells one side of the story.
Well, that's fine. What it is, it's the order. It's not the motion, ma'am.
Okay, well, it is evident that the plaintiff and I are not good for each other, and it is the best interest of all parties for us not to be together, which is why I left Calhoun County on 10/16. The plaintiff has contradicted himself many times by sending emails saying that I am a great mother, that he wishes we could be together, and asking me to come back. Many of those messages were from last week. If the plaintiff truly felt the way he states in this motion, then he wouldn't be sending me those messages and begging for me to get back together with him. I disagree with the plaintiff's statement that I provided an unsafe environment for our daughter, when in fact I uprooted my life and started over to provide a safe and stable environment for our daughter in Oakland County. I secured a home, stable employment, and stable childcare. Your Honor, I'm asking that you do not grant the plaintiff his motion for temporary parenting time. Your Honor, I left Calhoun County on 10/16, and the plaintiff was informed of our new home and was offered to see our daughter on 10/22. But he did not reply and did not ask to see her until 11/17, which was 30 days after we left Calhoun County. I've never tried to keep our daughter from the plaintiff. I offered the plaintiff parenting time with our daughter so that he could begin to build a relationship with her and learn how to take care of her, which is why I offered supervised parenting time. In the plaintiff's motion, he states that on 11:30, the police were called, and they were in fact called, but by the plaintiff. The plaintiff arrived to his parenting time with the police and tried to enter my home demanding to take our daughter, and my aunt is here and able to testify to this. Additionally, I have obtained the police report from that day. Your Honor, the plaintiff does not know how to make a bottle. He doesn't know our daughter's doctors, how to put her to sleep, how to console her when she's upset. He's never been alone with our daughter. I'm trying to act in our daughter's best interest. I have been our daughter's primary caregiver from the day she was born 6 months ago, and it would be detrimental to her to take her from her home in the only care she has ever known. I am respectfully asking that you grant the plaintiff the parenting time that I had previously offered to him, which was twice a week, 1 weekday for 2 hours and 1 weekend day for 3 hours of supervised parenting time, so that he can establish a relationship with her and learn how to care for her so that one day he is able to have unsupervised parenting time and we can have shared custody in the future. It is my genuine desire for the plaintiff to have a relationship with our daughter and get to know her and learn how to care for her. I'm just asking that he learns to do that before he is granted unsupervised time for her. Thank you.
Okay. Ms. Sharp?
Thank you.
Buckle up, guys, because today's courtroom battle begins with a mother who insists every decision she's made has been for her daughter's safety. She explains why she left, claims she repeatedly offered the father opportunities to see their child, and argues that supervised visits are the only responsible option until he gained parenting experience. It's an emotional opening that immediately raises questions about who's telling the truth, setting the stage for a heated custody dispute.
Honor, as my client, I guess he did not provide me an actual request to enter a temporary order, but I can definitely argue that the statements said by the defendant actually have a different timeline here. So it's said that my client has never taken care of the minor child, yet the parties lived together multiple different times throughout this period. So my client jointly had this child and was helping take care of the child. So this child is on formula, not on breast milk. She's on formula. And so my client has been able to and has done the formula before. He also has been left alone with his child before. This isn't the, he's the father. He knows how to take care of his child. It isn't that, he never lived with his child, now is asking for some kind of visitation because the child's never met him. Instead, it's mom just took off and left. And my client in September could see something was going to go on here, that mom was going to, be going back and forth, and he had concerns. And so he filed then, and then she came back. And then she left again October 16th. She then blocked him from him being able to talk to her. And then finally started allowing some kind of visitation. It was my client's birthday on the 30th. He tried to actually get his child. And she informed him he could have supervised visitation for a few hours. There's absolutely no reason why my client needs to have supervision whatsoever. He's never hurt this child, been physical. The only person that's been physical is the defendant. And, she physically actually assaulted my client while she was holding the minor child on October 16th. And so my client, is looking for, based off the physical assault, he was looking for sole primary custody, physical custody, but, if the court is inclined, he would, at least like joint physical custody where he could take care of the minor child, because there's absolutely no reason why he wouldn't be able to. And there's no kind of history, there's nothing alleged that's wrong with him, other than just claiming, that he can't take care of his child, yet he lived with the defendant for a while with the minor child in their care. So, Your Honor, my client would ask for at least, he would like joint legal custody. He'd like primary physical, but the court is inclined at least joint physical custody and a parenting time arrangement that's good for both parents and a minor child of that age, where the child does not go very long without seeing either parent. But my client is capable of doing overnights. He's capable of taking care of the child on his own without the defendant present.
All right, guys, now the father's side finally gets its tone, and the story changes dramatically. His attorney argues that he has always been involved in his daughter's life, knows how to care for her, and has been unfairly portrayed as an absent parent. According to the defense, the real issue isn't parenting ability, but the mother's decision to restrict his access. With both sides offering completely different versions of the same events, the judge has a difficult decision ahead.
Thank you.
Okay, thank you. We have that temporary order. I can't find it in there.
We do not. Not for the motion. Harris was the motion for temporary custody and parenting time. The temporary order was on the defendant's motion for NP.
Okay, so we didn't have another one.
We didn't.
Okay. Ms. Moore, what's your response to Ms. Sharp?
Your Honor, none of that is factually correct. We had lived with the plaintiff, but he had never once helped me ever. Maybe he would feed her every once in a while. He was not an active role in her life. He would go to work, he would come home, and then he would smoke and drink in his game room for hours. There was days I was begging him to help me and spend time with us, and he would not. Your Honor, he is not fit to take care of her. He has never woken up with her in the night, Your Honor. He has never done these things that you would do in overnight visits. He has never been alone with her for more than an hour, maybe while I run to the grocery store, Your Honor. None of this is factually correct. We never agreed on the unsupervised visit, so him showing up to my home with the police trying to force his way into my house was incredibly disrespectful, especially because we had an agreement and he violated that agreement and just made me feel like I can't trust him. He's showing up to my house with the cops. His living conditions are honestly a health hazard. I have pictures, I have videos. It's disgusting. There is an infestation of bugs. I am honestly worried for her well-being if she was to go unsupervised. This is why I'm trying to do supervised visits. It's been 2 months and he's seen her one time in the last 2 months. She's 6 months old. She does not know him, Your Honor. I'm asking for these supervised visits so they can build a relationship, so we can get to the point of unsupervised visits and sharing custody. I don't want to keep him from her, but I am honestly scared for her safety and well-being of him being alone with her.
Okay. Anything else, Ms. Sharp?
Yes. Okay, so the only reason my client has not been able to have contact with the child is because of the defendant. So
No,
if the
it's
defendant was
not.
concerned with the actual, the child having a relationship with the father, then she wouldn't have blocked my client and she wouldn't require supervised visitation, because supervised visitation, if it had started with visitation from the beginning in October, then I don't even know. To begin with, I'm not sure why supervision should occur, but regardless, if she would have allowed any kind of visitation in the October, then she wouldn't have that argument saying, he doesn't know the child.
Your Honor,
Regardless,
Ms. Moore, don't interrupt. Go ahead, Ms.
Thank you. And my client filed because he did not want to have parenting time dictated by the defendant, as it has been happening. He filed right away. It shows that he cared about having the child in his life, and he didn't know where Miss Moore would be going back and forth, back and forth. And so that is the reasoning why in the first place he filed. So it shows that he cared from the start and would like to have this child in his life as much as the court allows. Thank you.
Thank you. Ms. Moore, anything else?
Your Honor, he did not ask to see our daughter until November 17th. We left October 16th. He was texted by my aunt on October 22nd, and he was made aware of where we were, that we were living here, and he was given multiple dates and times that he could come see her. He never responded. And I think it's important to add too that he was never blocked. While we were living together, we had an agreement that I was a stay-at-home mom and he would pay my bills. He never paid my phone bill, so my phone was shut off. Any texts or calls he had sent me, I did not receive. He did not ask to see her until November 17th. I tried to do visits in October. He never responded, Your Honor.
Things become even more intense as a mother strongly rejects every claim made by the father's attorney. She describes his daily habits, questions his ability to care for the baby overnight, and even raises concerns about the condition of his home. The father's attorney quickly responds, insisting that any lack of a relationship exists because the mother prevented regular contact. At this point, the courtroom is no longer debating fact alone. It's about which version the judge finds more believable.
Okay. Well, he's asked now, so we have to address that at this particular point. So,
Your Honor, I am asking that we could go over the motion to transfer or dismiss because that was the first.
well, but you acknowledged that you had resided in Calhoun County prior to October 16th.
Yes, but
2023.
yes, but we have resided in Oakland County for 2 months now.
Well, that's not going to be a determinative factor as it relates to venue because you had resided in Calhoun County, and the court will find that Calhoun County is the proper venue at this point.
But however, when he filed it, we were living in Washtenaw County.
Well, he was residing here. He had a right to file in the county in which he resided. He did file, so the court is going to continue to take jurisdiction in this matter. What the court is going to do is on a temporary basis, the court is going to temporarily grant to the defendant legal and physical custody. The court is going to grant parenting time to the plaintiff, standard parenting time, but on the alternating weekends, that would be from Saturday at 9:00 a.m. to Sunday at 6:00 p.m., as well as the midweek on Wednesday, if the parties can other agree, for 4 hours. The court would grant to him alternating holidays in this matter during the standard alternating holidays, but I'm not going to extend that for a Christmas. I'm not going to break up the Christmas break. It'll just be the holidays themselves at this particular point. And the court would grant to the defendant child support based upon the respective incomes of the parties, based upon the child support formula as well. Ms. Sharp, you can prepare the order as it relates to custody, parenting time, and support in this matter and submit it under a 7-day notice of entry.
Thank you, Your Honor.
Anything else, Ms. Sharp?
I just want to make sure what weekend my client can start.
I will have that take effect starting this weekend on December 16th and then alternating each weekend thereafter.
Okay, thank you.
And why don't we do that too for the holidays? Put that. I'll ask Ms. Moore. Ms. Moore, do you wish to have Christmas Eve this year or Christmas Day?
Christmas Day.
Okay, we'll have the plaintiff would get Christmas Eve 2023 and then alternate each holiday thereafter.
Your Honor, just to be clear, you're granting the plaintiff unsupervised
Correct.
overnights for the
Correct.
weekend?
Correct. Okay.
So that goes for, can you go over the times again for the weekend?
The weekend would be Saturday, his alternate weekend, Saturday at 9 o'clock a.m. on Saturday to 6 o'clock p.m. on Sunday. And then the holidays would be based upon the front of the court holiday schedule. Those days, those times vary based upon the holidays. But Ms. Sharp will include that in the order. That will be the order. The court will end this matter at 10:54 a.m. You're free to go. Have a good day.
Now comes a moment everyone has been waiting for. After listening carefully to both sides, the judge first settles a jurisdiction issue before announcing a temporary custody decision. The mother keeps temporary custody, while the father is granted unsupervised parenting time under a structured schedule. Although neither side receives everything they requested, the court focuses on maintaining a relationship between both parents and the child while the case continues. If you enjoyed this courtroom breakdown, don't forget to like the video, subscribe to the channel, and we'll see you in the next video.